Case File 9007, Designation, Operation Phantom Ledger, Subject NexVault Exchange LLC, Sanctions Evasion, Unlicensed Money Transmission, Wire Fraud, Conspiracy, Originating Agencies, U.S. Department of the Treasury / Office of Foreign Assets Control, Federal Bureau of Investigation Cyber Division, Financial Crimes Enforcement Network, Stent Adjudicated, records partially declassified under FOIA Request 2024 TREAS 00441, Classification Downgrade Authority, Undersecretary for Terrorism and Financial Intelligence, May 2024. What follows is the reconstruction of a federal investigation into a cryptocurrency exchange that presented itself to the public as a fully licensed, fully compliant financial platform operating under American law. The principals behind it claimed to run a model business. They appeared at industry conferences. They published glossy white papers about regulatory responsibility. They corresponded warmly with state money transmitter licensing offices. They maintained a law firm on retainer whose letterhead they used to correspond with federal regulators. None of it was true in any material sense. Behind the compliant facade, NexVault Exchange LLC processed an estimated $4.2 billion across approximately 31 months, a substantial portion of which moved on behalf of entities whose names appeared on the specially designated nationals and blocked persons list maintained by the United States Treasury Department. The remainder included ransomware proceeds, darknet narcotics revenue, and funds connected to state-sponsored cyber intrusion programs that had already drawn federal criminal indictments. This is the file. The referral that initiated the federal investigation arrived at the Financial Crimes Enforcement Network on a Tuesday morning in the spring of 2021. It originated from the Treasury Department's Office of Foreign Assets Control, whose analysts had been monitoring wallet cluster behavior associated with a sanctioned Iranian financial institution, one listed under the Countering America's Adversaries Through Sanctions Act, and had observed a pattern suggesting that a domestic-facing exchange was functioning as an off-ramp for that cluster. The referral was one page. It named no individuals. It identified a wallet address, a transaction volume window, and a domain name nexvault.io. The analyst who drafted it, a senior compliance examiner who had spent 11 years tracking illicit financial flows at FinCEN before joining OFAC, later told investigators that she had initially flagged the cluster as a low-confidence lead and almost did not route it upward. She did route it. That decision would eventually result in criminal charges across 2 continents. FinCEN logged the referral under tracking number FTC 2021047882. Within 72 hours, analysts had cross-referenced the domain against their suspicious activity report database and located 14 prior SARs filed by domestic banking institutions against accounts connected to nexvault.io. Most of the SARs were low detail, transactions structured just below reporting thresholds, deposits followed immediately by outbound wire transfers, accounts opened with identification documents that did not survive basic verification. Taken individually, none of the SARs would have justified a full investigation. Taken together and cross-referenced against the OFAC referral, they formed a preliminary picture of a company that had been generating regulatory red flags for at least 18 months before the government's formal attention arrived. FinCEN referred the consolidated file to the FBI's Cyber Division Field Office in San Francisco. NexVault had registered its principal place of business in San Francisco, using a commercial mail forwarding address on Market Street. The company's state money transmitter license application had been filed with the California Department of Financial Protection and Innovation and, after a review period, had been approved. The approval, investigators would later determine, had been secured partly through the submission of a fabricated compliance manual, a document that described anti-money laundering procedures the company had never actually implemented, and partly through a favorable third-party audit report commissioned from a one-person consulting firm that shared a mailing address with one of NextVault's own registered agents. The FBI assigned the case to its Financial Crimes and Cyber Convergence Task Force, a unit that had been constituted 2 years earlier specifically to handle investigations at the intersection of traditional financial crime and digital asset infrastructure. The case agent of record was Special Agent Dominique Ferrara, a 12-year Bureau veteran who had come up through the financial crimes track before cross-training in blockchain forensics. Her supervising ASAC was Thomas Okafor, based at the San Francisco field office. The investigation was designated internally as Operation Phantom Ledger, a name chosen, Ferrara would later note in her case memoranda, because the defining characteristic of NextVault's operation was the systematic creation of financial records that appeared to document lawful transactions but documented nothing that had actually occurred. The first analytical task was to understand the architecture of the exchange itself. NextVault presented publicly as a retail cryptocurrency exchange, a platform where ordinary users could create accounts, complete identity verification, and convert between fiat currency and digital assets including Bitcoin, Ether, and several stablecoins. The platform's user interface was polished. Its website carried trust badges referencing its state license and its claimed FinCEN money services business registration. Its published terms of service ran to 47 pages and included detailed language about know your customer procedures and sanctions screening. A visitor to the platform in 2020 or 2021 would have seen nothing obviously irregular. The irregularity, as with most successful financial frauds, was entirely in what was not visible. The FBI's blockchain analysts, Special Agent Marcus Bellantoni and a contracted forensic specialist working under a task order from the Bureau's Digital Assets Analysis Program, began with the wallet cluster the OFAC referral had originally identified. Their methodology drew on commercially licensed blockchain analytics software as well as proprietary heuristics the Bureau had developed through prior investigations. The fundamental analytical problem in cryptocurrency fraud cases of this type is the nested wallet. Rather than moving funds directly from a sanctioned entity to a domestic exchange, sophisticated actors layer the transactions through chains of intermediate wallets, each holding funds briefly before forwarding them to the next address in the chain. The goal is to increase the number of hops between the illicit origin and the exchange deposit on the theory that compliance software will lose the thread. NextVault's operators had constructed nested wallet chains of between 7 and 19 hops in the cases the FBI analyzed. This level of nesting was toward the high end of what the Bureau's analysts had previously encountered. What made NextVault vulnerable to analysis was not the number of hops but the timing patterns of those hops. Bellantoni's reconstruction showed that the intermediate wallets were not operating independently and randomly, as would be expected if they represented genuine individual users moving funds for legitimate purposes. Instead, the wallets moved in coordinated pulses, batches of transactions forwarded within minutes of one another, at intervals that suggested automated execution rather than human decision-making. The coordination signature was consistent across wallets that, on their face, bore no relationship to one another. This kind of timing fingerprint is a recognized indicator of what blockchain analysts call a clustering cluster, a set of wallets under common operational control, managed through automated scripts, presenting the appearance of independent activity. The FBI analyst's conclusion, documented in a 41-page forensic memorandum dated August 2021, was that the wallet cluster identified in the OFAC referral was one of at least 6 such clusters funneling funds into NextVault accounts. The 6 clusters accounted for a substantial portion of NextVault's inbound transaction volume. When Bellantoni mapped the ultimate origins of those clusters, tracing backward through the hop chains to first-generation wallets. The picture that emerged was damning. One cluster traced to wallets directly associated with a sanctioned Iranian financial institution previously designated under CAATC. A second cluster showed origin connections to infrastructure wallets used by a ransomware group that the FBI's ransomware task force had been tracking under a separate investigation since late 2019. A third cluster's origins included addresses linked to a darknet narcotics marketplace that had been seized by the Justice Department, but whose operators had retained significant cryptocurrency holdings before fleeing to jurisdictions outside U.S. extradition reach. A fourth cluster showed partial origin connections to wallets involved in a prior sanctions evasion investigation involving North Korean state-affiliated actors, a matter that the Bureau's counterintelligence division had been monitoring separately for entirely different reasons. NextVault, in other words, was not a peripheral participant in illicit cryptocurrency flows. It was, by the forensic record, a significant and knowing facilitator. The question of knowledge, of what the principals behind NextVault actually knew and intended, was the central investigative challenge. Establishing that money moved through the platform was analytically tractable, given the public nature of blockchain ledgers. Establishing that the principals knew the money was illicit and chose to process it anyway required building a conventional evidentiary record. That record was built through three parallel tracks: a review of the company's internal communications and compliance records, an undercover operation, and the cultivation of a cooperating witness inside the company. NextVault was incorporated in Delaware in January 2019. Its two principal founders were Alexei Naumov, a 34-year-old Russian-born naturalized U.S. citizen who had previously worked in software development at a financial technology firm in New York, and Jordan Hess, a 31-year-old U.S.-born entrepreneur who had founded and sold a prior tech startup and who served as NextVault's public-facing CEO. Naumov held the title of Chief Technology Officer and was, by all accounts in the record, the technical architect of the platform. A third figure, identified in the indictment only as an unnamed co-conspirator whose prosecution was pending in a separate jurisdiction, managed what the company internally described as its institutional client relationships, a category of clients that, as the investigation established, meant the sanctioned entities and criminal networks the platform was secretly servicing. The internal communications review was made possible through a legal process the FBI executed in October 2021, a set of search warrants and production orders directed at NextVault's cloud service providers, email hosting companies, and the domestic banks that held the company's operational accounts. The legal process generated a production of approximately 340,000 documents, including emails, internal messaging logs from two enterprise chat platforms, administrative access logs for the exchange's back-end systems, and customer account records. The document review took 4 months and involved a team of 6 FBI analysts working in rotation with 2 contract document reviewers cleared for the investigation. The documents showed, in explicit and unambiguous terms, that NextVault's principals knew their platform was processing funds for high-risk and sanctioned clients. An internal email from Naumov to Hess, dated March 2020, described one institutional client as, quote, the Tehran account, and discussed the need to, quote, keep the KYC shell intact for the quarterly review. A chat log from the same month showed Naumov discussing with the unnamed third co-conspirator a technical adjustment to the platform's sanctions screening configuration, a change that, in practice, would cause the system to fail to flag wallet addresses appearing on the OFAC SDN list. The change was framed in the chat log as a, quote, tolerance calibration to reduce false positives, but the effect, as blockchain analysts confirmed, was to disable meaningful sanction screening for the category of wallets the sanctioned clients were using. A series of messages from late 2020 showed Hess communicating with a client he referred to only by a code name about the client's upcoming, quote, deposit cadence. a phrase that in context referred to the scheduled inbound transaction batches from a ransomware group that had recently executed a significant attack on a U.S. hospital network. The documents also exposed the mechanics of NextVault's Know Your Customer fraud. Federal law requires money services businesses to collect and verify identifying information from their customers. NextVault had a published KYC policy as noted. The documents showed that this policy was selectively applied. Retail customers, the ordinary users who made up the compliant face of the business, were subjected to genuine identity verification. Institutional clients, meaning the sanctioned and criminal clients, were processed through what internal records described as the enhanced onboarding pathway, a phrase that in the document's context meant the opposite of what it suggested. These clients were onboarded using fabricated identity documents, front company registrations sourced from foreign jurisdictions with weak corporate transparency laws, and in several cases, identity documents belonging to individuals who had no knowledge that their information was being used. The enhanced onboarding pathway generated KYC records that, on their face, showed a verified business customer. Examined with full context, those records documented nothing about the actual beneficial owners of the accounts. The undercover operation ran concurrently with the document review. In December 2021, an FBI undercover agent, designated in court records as UC1, a bureau employee with background in financial technology, created an account on NextVault's platform using a legend identity and initiated contact with the platform's institutional client services team. UC1's stated purpose over a series of communications with platform staff was to establish an institutional account for a company that he represented as having, quote, complex offshore revenue streams with confidentiality requirements. This language was chosen deliberately. It was the kind of language that a legitimate compliance operation would receive with caution, escalate to legal counsel, and likely decline to service. NextVault's response was different. Within 4 business days of UC1's initial inquiry, he was connected via encrypted messaging application with a platform representative who identified himself only as a relationship manager. Over the course of 6 subsequent communications, the relationship manager walked UC1 through a process that the representative described as the platform's premium institutional setup. This setup, as the representative explained it, involved the creation of an account under a foreign corporate entity rather than in UC1's personal name, the acceptance of deposits from wallets that the representative acknowledged, in explicit terms, would not be, quote, traceable back to retail history, and a fee structure that included a premium above NextVault's published rates, which the representative described as the discretion premium. The discretion premium, as the representative made clear, was compensation for the platform's willingness to accept clients that other exchanges would decline. These conversations were recorded with full legal authority under a Title III interception order obtained in November 2021. UC1 subsequently made 2 test deposits through the account, totaling approximately $40,000, following the exact process the relationship manager had described. Both deposits cleared without triggering any compliance flags in NextVault's visible systems. The cooperating witness was recruited through a separate channel. In the course of the document review, investigators identified an employee in NextVault's compliance department, a person designated in the court record as CW1, whose internal communications showed a pattern of raising concerns about specific client accounts and being directed by Naumov and Hess to close those concerns without filing external reports. CW1 had raised concerns about at least 4 client accounts that blockchain analysis later confirmed were connected to the sanctioned and criminal clusters. In each instance, CW1's internal escalation had been met with direction from leadership to, quote, reclassify the flag as resolved, a designation that in NextVault's internal system marked the matter as closed without any external regulatory reporting. CW1 had complied with these directions each time. The compliance employee appeared, in other words, to be someone who understood what was happening, was uncomfortable with it, and had not yet found a way to extricate themselves. Investigators approached CW1 in February 2022 through a carefully managed contact, first through a pretext, then through a direct disclosure of the investigation after CW1's attorney had been engaged and had communicated a willingness to cooperate. CW1's cooperation agreement was finalized in March 2022 in exchange for truthful testimony and full disclosure of their knowledge of the scheme. CW1 received a deferred prosecution agreement under which charges would be dismissed upon completion of the cooperation period. CW1's knowledge proved to be extensive. As a compliance employee with system-level access, CW1 had direct knowledge of the sanctions screening configuration changes, the enhanced onboarding pathway, and the instructions Naumov and Hess had given regarding suppression of internal compliance flags. CW1 also provided investigators with the identity of the unnamed third co-conspirator, information that, consistent with the terms of CW1's agreement, was provided to investigators and used in the charging documents, but whose prosecution proceeded on a separate timeline in coordination with foreign law enforcement partners. By the autumn of 2022, the investigation had reached the stage at which the evidence package was sufficient for a federal grand jury presentation. The case was referred to the U.S. Attorney's Office for the Northern District of California, where an AUSA specializing in cryptocurrency and financial crimes took on the prosecution. Grand jury proceedings began in November 2022 and ran for approximately 3 months, with testimony from Special Agent Ferrara, the FinCEN analysts, and CW1 as the primary grand jury witnesses. Blockchain forensic testimony was provided through a written expert summary submitted under seal, with the expert available for examination if requested. The grand jury returned a sealed indictment in February 2023. The indictment charged Alexei Naumov and Jordan Hess with 1 count of conspiracy to violate the International Emergency Economic Powers Act, 3 counts of violations of IEEPA related to specific sanctioned entity transactions, 1 count of operating an unlicensed money transmitting business under 18 U.S.C. 1960, 1 count of conspiracy to commit money laundering, and 2 counts of wire fraud. Naumov faced an additional charge of computer fraud related to the sanctions screening configuration changes, which prosecutors characterized as an unauthorized modification to a financial system for the purpose of facilitating sanctions evasion. The operational takedown was scheduled for March 14, 2023. The timing was chosen to coincide with a moment when NextVault's servers were at low traffic volume early on a Tuesday morning, in order to minimize disruption to lawful customers' accounts while allowing for a clean seizure of the platform's operational infrastructure. The operational plan involved 3 simultaneous elements: the arrests of Naumov and Hess, the seizure of the exchange's servers and domain name, and a coordinated civil action by Treasury's OFAC imposing sanctions designations on the platform itself. At 6:15 in the morning on March 14th, a 7-agent arrest team from the FBI's San Francisco field office executed an arrest warrant at Naumov's residence in the Sunset District neighborhood. The residence was a single-family home that Naumov had purchased in 2021 for $1.8 million, a purchase that investigators noted in their financial profile as inconsistent with his disclosed income as a technology executive at a modestly funded startup. Naumov answered the door himself and was taken into custody without incident. He made no statement at the scene. His attorney, who had evidently anticipated the possibility of arrest based on informal signals from the legal process, was notified and arrived at the federal building within 2 hours. Simultaneously, a second arrest team executed a warrant at Hess's condominium in San Francisco's Soma district. Hess was not present. A concierge at the building's front desk confirmed that Hess had left the prior afternoon with luggage. A subsequent check of travel records showed that Hess had departed San Francisco International Airport on a flight to Zurich the previous evening, approximately 12 hours before the arrests. Investigators later assessed that Hess had received some form of warning, though the precise source of that warning was not definitively established during the investigation. A fugitive arrest warrant was issued the same morning. Hess remained at large as of the filing of the initial indictment, and his case was referred to the FBI's International Operations Division and through Interpol channels. He was apprehended in Lisbon, Portugal in September 2023 following cooperation between the Bureau, the U.S. Marshal Service, and Portuguese law enforcement, and was extradited to the United States in January 2024. The server seizure was executed by a team of FBI cyber agents who served legal process on NextVault's cloud infrastructure providers, a data center in Ashburn, Virginia, and a cloud computing platform whose servers hosted the exchange's matching engine and customer database. The servers were imaged, and the domain name nextvault.io was seized and redirected to a federal government notice page within approximately 90 minutes of the beginning of the operation. The exchange went dark at 6:47 that morning Pacific Time. Approximately 14,000 active user accounts were affected. In coordination with the seizure, Treasury's OFAC issued a press release designating NextVault Exchange LLC as a specially designated national, a designation that, among other effects, made it a federal civil violation for any U.S. person to maintain business dealings with the platform or its assets. Among the assets seized in connection with the case were approximately $280 million in cryptocurrency held in NextVault's custodial wallets, funds attributable to the exchange's operations that investigators had been able to identify and trace prior to the seizure. An additional $47 million in fiat currency held in NextVault's domestic bank accounts was seized pursuant to civil forfeiture warrants. A residential property in the Napa Valley area, purchased in Naumov's name in 2022 for approximately $2.1 million and identified by IRS investigators as having been acquired with laundered proceeds, was separately restrained pending forfeiture proceedings. Investigators also identified and restrained a series of foreign bank accounts in the names of offshore entities connected to the platform, a process that required the execution of mutual legal assistance treaty requests to 3 foreign jurisdictions and took the better part of 18 months to complete. The mechanics of how NextVault had managed to operate for 31 months while processing sanctioned transactions deserve close examination, because the investigation's record documents a number of specific techniques the principals employed to maintain the appearance of compliance while systematically undermining it. The licensing shell was the first line of defense. NextVault held a California money transmitter license and an active FinCEN MSB registration. These credentials were real. The investigation established that they had been obtained through the submission of false and misleading information, but the licenses themselves existed and were publicly verifiable. When regulators or banking partners inquired about NextVault's compliance status, the company could point to real license numbers. The compliance manual submitted during the California licensing process was fabricated. It described specific staffing, procedures, and systems that did not exist, but the license it produced was genuine. This kind of false predicate licensing, using accurate lies to obtain true credentials, is a recognized vulnerability in the financial licensing ecosystem that this case helped prompt several state regulators to address. The third-party audit fraud was the second line of defense. NextVault had commissioned what it described to banking partners as an independent compliance audit confirming its AML procedures. The audit had been conducted by a sole proprietor consulting firm whose principal had a prior working relationship with Naumov dating to his time at his previous employer. The audit report certified compliance with Bank Secrecy Act obligations, described transaction monitoring procedures that matched NextVault's published policies, and was formatted to look like the output of a credentialed consulting practice. In reality, as the investigation established, the auditor had spent less than 2 days reviewing materials supplied by Naumov, materials that described the legitimate retail-facing side of the business and omitted any reference to the institutional client operations. The auditor cooperated with investigators and testified before the grand jury. He was not charged, having been assessed as a victim of Naumov's selective disclosure rather than a knowing participant in the fraud. The audit report, however, had functioned as a reputational shield. Banking partners who received it as part of NextVault's compliance documentation had reduced their scrutiny of the company's account activity as a result. The KYC shell construction was the third layer. The fabricated identity documents used to onboard institutional clients were sourced, the investigation found, from two channels. One was a foreign corporate formation service operating in a jurisdiction that did not require beneficial ownership disclosure, which provided shelf companies with local registration and nominee directorship arrangements. These companies' names, registration numbers, and addresses appeared on the KYC documentation NextVault maintained for its sanctioned clients, creating a paper trail that looked, to a cursory review, like a verified business-customer relationship. The second channel was more concerning. Several of the identity documents used in the KYC records were associated with individuals whose information had been obtained through data breaches, people who had no knowledge that their identifying information was being used to create financial accounts. This element of the case generated an additional set of potential victims who were notified by the Bureau following the arrests. The nested wallet architecture, as described by the blockchain analysts, served the fourth layer of concealment. The construction of 7 to 19 hop chains between sanctioned wallets and NextVault deposit addresses was time-consuming and operationally complex. It required the maintenance of a significant number of intermediate wallets, which in turn required operational security discipline to avoid linking those wallets back to the exchange through transaction patterns. The coordination of these chains with the timing of institutional client deposit schedules, the quote cadence discussed in Hess's encrypted communications, suggested a level of operational planning that investigators characterized as sophisticated and intentional. What ultimately defeated this architecture was not any single vulnerability, but the intersection of two independent analytical threads. The OFAC referral identified the sanctioned wallet cluster but would not, on its own, have produced enough evidence to trace the connections to NextVault. The FinCEN Suspicious Activity Report database identified anomalous account behavior connected to NextVault.io, but without the blockchain forensics would not have established the magnitude of the sanctioned flows. The merger of these two threads in the hands of analysts with experience in both traditional financial crime investigation and blockchain forensics produced a unified picture that neither thread could have produced alone. This convergence model, the deliberate cross-referencing of traditional financial intelligence with blockchain analysis, became in part as a result of this investigation a more formalized element of the interagency referral process for cryptocurrency-related financial crime. The prosecution of Alexei Naumov proceeded to trial in the Northern District of California in November 2023. The government's case rested on the forensic blockchain evidence, the internal communications documents produced through the search warrant process, UC1's testimony about the undercover account and the relationship manager's admissions, and CW1's testimony about the internal suppression of compliance flags. Naumov's defense raised two primary arguments. First, that the blockchain analysis methodology was insufficiently reliable to establish beyond a reasonable doubt that the specific transactions at issue had originated with sanctioned entities, and second, that Naumov had been deceived by the unnamed third co-conspirator about the true nature of the institutional clients and had genuinely believed the company's compliance procedures were adequate. The jury deliberated for 4 days and returned guilty verdicts on all counts. Naumov was sentenced in February 2024 to 14 years and 3 months in federal prison. The sentencing court noted, in its remarks from the bench, that the scheme had provided material financial benefit to sanctioned entities whose activities had caused direct harm to American interests, and that the deliberate and sustained nature of the evasion warranted a sentence that would reflect the gravity of the conduct. Jordan Hess, following his extradition from Portugal, entered into plea negotiations with the government in March 2024. Under the terms of a plea agreement, Hess pleaded guilty to 1 count of conspiracy to violate IEEPA and 1 count of operating an unlicensed money-transmitting business, with the remaining counts dismissed. He agreed to cooperate with the government's ongoing investigation into the unnamed third co-conspirator and into the foreign corporate formation service used to construct the KYC shell documentation. Hess was sentenced in September 2024 to 9 years and 8 months in federal prison, with the reduced sentence reflecting both his cooperation value and the government's assessment that, while he was a knowing participant in the scheme, the technical architecture of the evasion had been primarily Naumov's design. The civil and regulatory consequences of the case extended beyond the criminal proceedings. NextVault Exchange LLC itself was, following the OFAC designation, referred to FinCEN for an assessment of civil money penalties, a process that was complicated by the company's insolvency following the asset seizures. The seized cryptocurrency, the approximately $280 million in custodial wallets, became the subject of a complex forfeiture proceeding involving claims by lawful customers who had held funds in the platform. The court appointed a restitution administrator whose mandate was to identify lawful customers' holdings, separate them from funds traceable to illicit transactions, and return them to their rightful owners. As of the most recent public status report, approximately $142 million had been identified as attributable to lawful retail customers and was in the process of being returned through a claims process administered by the court-appointed administrator. The California Department of Financial Protection and Innovation revoked NextVault's money transmitter license following the federal charges and initiated an administrative proceeding against the third-party auditor, resulting in a finding that his audit report had contained material misrepresentations, irrespective of whether those misrepresentations reflected his knowing participation in the fraud. The state body also announced a review of its audit submission requirements for license applications, with the stated goal of requiring third-party auditors to undergo a credentialing verification process and to certify that their review had included access to client account-level data rather than management-provided summaries. FinCEN separately issued updated guidance to the money services business community regarding the indicators of the kind of nested wallet architecture this case had documented, guidance that drew directly on the analytical methodology developed by the Bureau's task force during the Phantom Ledger investigation. The third co-conspirator's case remained pending in a foreign jurisdiction as of the most recent available reporting. Mutual legal assistance treaty requests were active, and the unnamed individual had been the subject of an Interpol red notice. The investigation into the foreign corporate formation service used to construct the KYC documentation resulted in law enforcement action in the relevant foreign jurisdiction, the specifics of which remained classified under the originating country's disclosure laws. Several aspects of this case are worth noting for what they reveal about the architecture of cryptocurrency-based sanctions evasion at the level of sophistication NextVault represented. The principals were not unsophisticated actors improvising a simple pass-through scheme. They were technically capable individuals who had studied the compliance landscape carefully enough to understand its weaknesses, and who had built a business designed specifically to exploit those weaknesses while maintaining the superficial appearance of regulatory conformity. The licensing shell, the false audit, the KYC fabrication, the nested wallet architecture, each element addressed a specific vulnerability that genuine compliance would require to be addressed, and each addressed it not by actually solving the compliance problem but by creating a document or record that would be encountered before the compliance problem was discovered. What the principals appear to have miscalculated was the evolution of the investigative tools available to the agencies arrayed against them. The blockchain analytics methodology that Agent Bellantoni and his colleagues employed in 2021 was significantly more powerful than it had been even 3 years earlier. The timing pattern analysis that identified the coordination signature of the nested wallet clusters was a technique that had been refined through multiple prior investigations and that the principals do not appear to have accounted for in their operational security planning. They appear to have assumed that the number of hops was the primary variable determining the detectability of their flows, and that sufficient hops would defeat analysis. The timing fingerprint defeated them not because of how many hops there were, but because of how the hops moved, together, in patterns, in ways that human behavior would not produce. There is also the evidentiary value of what the principals wrote down. The internal communications record in this case was unusually explicit. The phrase "the Tehran account" in Naumov's own email is a direct statement of knowing engagement with sanctioned entities. The phrase "discretion premium" from the relationship manager's recorded conversation with the undercover agent is a direct statement of knowing facilitation of non-compliant transactions. Financial frauds of this sophistication are often prosecuted on the basis of circumstantial evidence, the inference, drawn from financial records and expert testimony, that the principals must have known what they were doing. Operation Phantom Ledger had direct evidence of knowledge in addition to the circumstantial case. The internal communications discipline that might have protected Naumov and Hess, the operational security practice of not committing the nature of illegal transactions to writing, was evidently not followed. Their own words became the clearest evidence of their intent. For the lawful users of the platform, the 14,000 account holders whose access was cut off on the morning of March 14th, the resolution of the case involved months of uncertainty and a claims process that, by the administrator's own assessment, was among the more complex retail cryptocurrency restitution exercises the district court had overseen. Most eligible claimants eventually received returns that represented a significant fraction of their account balances. A minority of claims remained unresolved pending appeals or additional documentation requirements. The experience reinforced a point that regulators had been making for years: the existence of a money transmitter license and a published compliance policy does not, in itself, protect consumers from an exchange whose principals have decided to use their platform's infrastructure for purposes other than those disclosed. This file is closed as to the principal defendants. The associated investigations into the corporate formation service and the third co-conspirator remain active. Asset recovery proceedings continue. Case File 9007, Operation Phantom Ledger, End of Declassified Record. The record of this investigation is maintained at the U.S. Department of Justice, Northern District of California, and at the Financial Crimes Enforcement Network. Portions of this file remain classified at the secret level, including materials related to the foreign co-conspirator investigation and to intelligence equities associated with the sanctioned entity wallet cluster analysis. The declassified portions released under FOIA Request 2024 TREASURY represent the public record as of the date of that release and should not be construed as a complete account of all investigative activity associated with the matter.